The sixth fundamental freedom provided under Article 19, Clause 1 is freedom of profession. And this very freedom of profession we would like to discuss with certain important leading cases such as Lakhan Lal versus State of Odisha in 1977. The very expression of the Supreme Court is that the right guaranteed by Clause G, subclause G of Article 19, Clause 1, namely freedom of profession, trade, or business, is intended to ensure that citizens' right to business do not depend on grant by the state, and that the state cannot prevent a citizen from carrying on business except by a law imposing a reasonable restriction in the interest of the general public. Of course, there is no right where the business is dangerous or immoral. Such a business may be absolutely prohibited or may be required to be licensed. Moreover, there is no right to carry on a business at any place or at any time. Restrictions may be imposed in that regard. A citizen cannot be compelled to do a certain business, as it was the observation made by their lordship of the Supreme Court in Lakhan Lal versus State of Odisha. And now we'll go to the second most important leading case, and that is relating to freedom of profession, and that is Maharashtra Ekta Hackers Union versus Municipal Corporation Greater Mumbai in 2004. The Supreme Court decided that the hawkers have a right under Article 19, Clause 1, Subclause G. This right, however, is subject to reasonable restrictions under Article 19, Subclause 6, as it was decided in this leading case. And now we'll go to another important leading case, and that is relating to Rajasthan Pradesh Sardar Shekhar Shah versus Union of India, and it was a case of 2010 where Supreme Court decided that the restriction placed on right of holders of degree or diploma of Vidya, Visharad and Ayurved Ratna from Hindi Sahitya Sammelan does not offend Article 19, Clause 1, Subclause G. And after that, we will go to another important leading case, that is Indian Medical Association versus Union of India in 2011. Supreme Court observed that education can be an occupation under Article 19, Clause 1, Subclause G of the Constitution only when charitable in nature, as it was decided in this very leading case, Indian Medical Association versus Union of India in 2011. And now we'll go to another important leading case, State of Madhya Pradesh versus Nandlal Jaiswal in 1987. Supreme Court expressed that in the context of license and permits required for carrying on a business or trade, the great grant of such license cannot depend upon the absolute discretion of an administrative authority. The policy must be laid down on which the discretion is to be exercised. Further, in general, the discretion must be exercised on relevant consideration. In short, if the law imposing license does not set out the consideration, the law would be void. If the considerations are set out in the law but are departed from by the competent authority while administering the law, then the order of the competent authority would be void, even though the law itself may be valid. Generally, an existing license cannot be revoked without giving the licensee an opportunity of hearing, as it was decided in this very important leading case. And now we'll go to another important leading case, and that is relating to Indian Handicraft Emporium versus Union of India in 2003. Supreme Court made this decision that dealing in imported ivory so long the law permits may be a fundamental right, but if the statute prohibits it, it must be held to be a law within the meaning of clause 6 or clause G of at subclause G of clause 1 of article 19 in terms whereof reasonable restriction is imposed. A trade which is dangerous or to ecology may be regulated or totally prohibited, as it was decided in this very important leading case, Indian Handicraft Emporium versus Union of India in 2003 by the Supreme Court. And now we will go to the next important leading case relating to this, that is the leading case of State of Punjab versus Diwan's Modern Breweries Limited 2004, where the Supreme Court made the observation that there is no fundamental right to carry on business of intoxicants under Article 19, Clause 1, Subclause G of the Constitution. The state has the exclusive right or privilege in manufacturing and selling or granting license and imposing restrictions on liquor, as it was decided in this leading case, State of Punjab versus Diwan's Modern Breweries Limited in 2004. And the next important leading case, that is State of Kerala versus Kedarnath Distilleries in 2003, the Supreme Court expressed that the state can prohibit completely trade or business in portable liquor. And the last important leading case relating to freedom of profession is Kerala Hotels or Kerala Bar Association versus State of Kerala in 2016. Supreme Court observed a right under Article 19 Clause 1 Subclause G to trade in liquor does not exist provided the state permits any person to undertake this business. It is further qualified by Article 19 subclause G and Article 47 of the Constitution as it was decided in Kerala Bar Hotels Association versus State of Kerala in 2016 by the Supreme Court. And now we'll discuss some other important leading case relating to freedom of profession, such as the leading case relating to right to occupation. And in that connection, we'll discuss one important leading case senior divisional commercial manager, Indian Railway versus South Central Railway caterers. So, in that particular leading case, the Supreme Court made the following decision: if there is no ground of denial and if the license is refused illegally, then it amounts to deprivation of the right to freedom of occupation guaranteed under Article 9, Clause 1, Subclause G, as well as right to livelihood. And another important leading case that relating to trade in liquor. And as regarding that, we will discuss the same important leading case, that is Kerala Bar Hotels Association versus State of Kerala in 2016. It was the decision of the Supreme Court that the prohibition of public consumption of alcohol is a positive step towards bringing down the consumption of alcohol. And so also in another important leading case, and that is relating to Amarjit Singh Sidhu versus State of Punjab in 2016, and so also in the very leading case Center for Public Interest Litigation versus Union of India in 2012, Supreme Court made this decision that the trade of liquor can be completely prohibited by state. The fundamental rights enshrined under Article 19, Clause 1, Subclause G of the Constitution are not absolute. The state is empowered to restrict or prohibit trade which are injurious to health and welfare of public. The citizens cannot claim fundamental right to trade or carry on business in such activities, and portable liquor is one which falls in such category, as it was decided in this very important leading case. And now we'll go to another important aspects relating to freedom of profession, and that is business aspects of the media houses. So, in that connection, we'll discuss one important leading case, and that is A. Suresh versus State of Tamil Nadu, which was decided in 1997. The Supreme Court made the following decision that where an activity involves question of freedom of speech as well as question of freedom to carry on a business, profession, or vocation, then it is legitimate for the state to regulate the business aspect in terms of Article 19, Clause 1, Subclause G. And another important aspect relating to freedom of profession is business with government. And in relation to that, we will discuss an important leading case, and that is State of Punjab versus Raja Saheb Ram Jamaya Kapur, and also State of Odisha versus Hari Narayan. And also another one is that State of Uttar Pradesh versus Vijay. In these cases, it was observed by the Supreme Court there is no right to carry on business with the government as such, nor is here a right that one's product, for example, textbooks, must be recognized by the government, nor there is any right that a public auction or in tenders invited by the government, the highest bid or the lowest tender must be accepted. But by virtue of Article 14, it is now established that rejection of the highest bid or the lowest tender by the government must not be arbitrary. So, all these are the important leading cases and the very decisions of our apex court in relation to freedom of profession, occupation, trade, business, commerce, etc., and those reasonable restrictions which could be imposed by the state, and such reasonable restrictions imposed by the state as under any law must not be arbitrary and must not violate and infringe the very fundamental rights. So also any statutory authority given to administrative act executives or any administrative action or discretion must not be violative of the fundamental rights, neither it must should be arbitrary in nature. So this is all relating to fundamental freedoms and reasonable restrictions as we found with all the provisions of these six fundamental freedoms available under Article 19, Clause 1, under subclause A, B, C, D, E, and G, and as subclause F was removed or deleted from these fundamental freedoms under the 44th Constitutional Amendment Act 1978 and the 6th subclass of Clause A, that is Clause G, which provides freedom of profession and occupation, trade, business, commerce, etc. So, almost we have completed all these fundamental freedoms with the reasonable restrictions which could be imposed by the state in the interest of public order public safety, morality, sovereignty, and integrity of the state, and as relating to their very explanation and examination of such reasonable restriction in the context of the decisions of Supreme Court in relating to all these subclauses provided under Article 19 Clause 1, we have finished, and in our upcoming video we would like to discuss the left out portions of law of contract, and that is relating to Sale of Goods Act 1930 and the Indian Partnership Act 1932.